It is quite common for contracts to involve tendering performance. That is, one party has the obligation to provide some sort of service. Consider every time you hire a mechanic, or you hire a babysitter, or you hire a housekeeper. These are all circumstances in which one party has the obligation to tender performance. Now, there are a couple general rules that you need to be aware of before we move on. The first rule is that if one party is obligated to tender performance, the other party has to give them the opportunity to do so. This is similar to the circumstances regarding a debtor who has to pay money. It's the other party's obligation to let the party provide its services. If the party does not, then the party whose obligation it was to tender performance may have a claim for damages, and their obligations are discharged. The other rule to consider is that the default rule is that a party's obligations have only been performed if they have been performed in the exact description that's contained in the contract. One question that arises when it comes to the performance of obligations is whether they need to be done by a certain date. The general rule is that time is not of the essence. What does that mean? That means that the parties, if they agree to, say, fixing a car, I go hire a mechanic and we agree that the mechanic is going to fix my car this week. The general rule is that time is not of the essence, and therefore the mechanic will be able to fulfill their obligations by fixing my car even next week. What's going to happen is that my recourse is going to be through damages. The mechanic is going to be obligated to pay for the additional week of a rental car because they failed to fulfill their obligations on the date they became due. But it's important that the mechanic is entitled to discharge their obligations by tendering performance even after the date that we've agreed upon in the contract. This is why you will see in many contracts a clause that says the time is of the essence. This is a clause that the parties agree upon that says that if there is failure to perform by a certain date, that can be considered a substantial breach of the contract, breach of a major condition of the contract, we'll go into that later, that can allow one party to discharge the contract, or it'll set out specific damages. There are certain circumstances, in addition to where the parties agree, where a court will find that time is of the essence. First, a court is always going to say that the parties have agreed that performance be tendered within a reasonable time. Again, you probably, as an astute business person, don't want a judge to decide what constitutes reasonable time. There's a lot of uncertainty there. The best avenue is to enter into an agreement where there is a clause that says time is of the essence and addresses late performance. There is another circumstance, though. It's possible that a court is going to look and say that there's an implied term, that the parties, as a natural part of their agreement, the nature of their agreement, the business efficacy, we talked about this in the last chapter, that a court is going to be willing to imply a term of time is of the essence. Say, for example, if you're ordering pizza. If you order pizza and for delivery, the service, the performance that's going to be tendered is going to be the delivery of that pizza. It's probably safe to assume that the implied condition is that pizza be delivered within a reasonable period of time, i.e. that night, unless you stipulate different when you order it on the app and say, I would like it delivered next week. The other rule to be aware of is the general rule that a contract must be performed exactly as it is outlined in the agreement, regardless of whether or not this causes economic loss. Say, for instance, you hire a housekeeper, and as part of the terms, the housekeeper is to clean your house every Tuesday in between 9 and 1. If the housekeeper shows up at 8:30 and cleans from 8:30 until 12:30, technically they have not properly performed their obligations under the terms of the contract. The duration of this video is going to look at circumstances in which performance isn't exactly as it is written in the contract. What happens if performance is substantial but not complete? What happens if performance isn't complete or substantial? What if a party completely fails to perform? Who has rights and who has obligations in those circumstances? Let's take a look. There are going to be circumstances in which a party provides performance. However, that performance is defective or incomplete in some minor way. That is to say, their performance is going to be considered substantial. They have substantially performed their obligations under the contract. If they have done so, a party is discharged from fulfilling the rest of its obligations. It has completed its obligations. This is not a circumstance in which they are able to do 90% of a job and not and still get compensated for the additional 10%. What it means is that they have discharged their obligations, and therefore the contract still exists. I have to pay the 90%, but I'm entitled generally to deduct the additional 10 that they failed to perform. Consider the example of building a house. I hire a contractor to build a house for $100,000. The contractor completes the job. However, it is defective in the sense that they forgot to put on doorknobs. Now, the contract has been substantially performed. So the builder has fulfilled their obligations. I'm going to have to pay the builder. What I am going to be entitled to do is deduct from the amount that I owe the builder the amount that it's going to cost to complete performance. How much money is it going to cost to put the doorknobs onto all of my doors? Now, the previous example that I've given you is of the default application of substantial performance. Of course, the parties are always within their ability to enter into a contract that has terms that specifically address what happens if performance is less than perfect. One such term that a parties can enter into is called an entire contract clause. And what this clause says is basically, I don't have to pay you a thing until the entire contract has been performed. So take the example of building a house. If the contractor builds the house but fails to put on the doorknobs and fails to put on the baseboards, if there is an entire contract clause in the agreement, the builder is not going to get, I won't have to pay the builder anything. Under substantial performance, I would, but because we have that clause in there, I don't have to. I don't have to pay him until the entire contract is performed. Obviously, it's not in the builder's interest to have that type of clause, and you're probably not going to see it in that type of agreement. Where the entire contract clause gets a little more nuanced is what happens afterwards. Say my builder doesn't put on the doorknobs, doesn't put on the trim, but he leaves everything here. If I choose to hire someone to then fulfill the end of the bargain by putting on the doorknobs and the baseboards, I am going to have to pay the builder for the materials that have been used, because I have voluntarily taken those benefits after the contract has been breached.